idea is, okay,
Oh, there we go.
we're up. Okay, so he is listening. So, okay, sorry, I'm gonna start formally now.
All right.
And then I'll get back to your question. My name is Jeb Penny. I'm the acting general counsel here at the Kentucky Public Service Commission. To my right, we have Daniel Hinton with our financial analysis branch. Ben Bellamy there in the middle. He is a staff attorney here. And we have Jeff Klein with our filings division back over there. We are part of a group of PSC employees that have been reviewing our regulations at the Public Service Commission, and we have put out several of them for a bit of informal feedback from the utilities and different stakeholders. The purpose of it is that our regulations need updating in some regard. They need some changes, and we actually have two new regulations that we're here to discuss today, one relating to pole attachments and one a general definition section, as well as changes to existing regulations 807 KAR 5001, which is our general procedures, 5006, which is regulation addressing general matters, and 5011, which is the regulation addressing tariffs. The proposed changes on this are not in any way set in stone. We've set these out for the point of eliciting comments and a conversation back and forth. I believe Ms. Call noted that written comments are not due until April 17th. So you have plenty of time to digest what we've said here. And this is in no way meant to replace the regulation promulgation procedure set under KRS Chapter 13A, which requires all sorts of formal filings in a proper format and notice and meetings and a comment cycle, the like of that. So that the purpose of what we're doing here today and over the next several months will be to winnow down as many issues and try to find consensus where we can on the changes in the regulations. These regulations have been grouped together for review because they're of general applicability, the procedures, the tariffs, the general matters, and because in the general matters regulation 5006, we are proposing to eliminate the section on pole attachment and have drafted a starting point, a starting regulation for the pole attachment regulation. We thought we would put that in there with the rest of them, knowing that it probably would generate some of the most interest among a lot of the utilities. So with that being said, I want to clarify something we were discussing before the meeting began, is that I don't think anybody here really wants to discuss the definitions, the proposed definitions regulation. It's just taking definitions from certain regulations, all of our regulations, and putting them in one spot so you use that to apply to the rest of them. And then we have 5001, which is our general, rules of procedure, which means how do you file things with the commission and the like, but it's not the reporting that I think the gentlemen from Meade County are interested in. So if that being the case, we can jump to our discussion. And I want to say, does anybody have a question about the tariffs? I know that Charter doesn't have to worry about that, and probably the Kentucky KCNA does not have to worry about that, but there's not substantive changes there, and we can always discuss that later. Would you wish to discuss the tariffs regulation?
No, we are not prepared to talk about that.
Okay.
That's another group of ours.
All right, that sounds good. And that's the point. I just want to see if there are any efficiencies we can gain out of this. So why don't we jump to discussion of our general matters? And I believe you had a specific question relating to reporting. Is that correct?
Yes, yeah, section, like I said, 500, over in section 25 of 5006, yes.
Okay. Let me pull that up. Do we have?
Should come up.
Yeah.
Okay, so, and let me know if I'm putting words in your mouth.
Okay.
But, so one of the concerns is that here in 25A, death or shock or burn requiring medical treatment at a hospital or similar facility being changed to injury.
Yes.
We had a few people comment on that. That might be a little overly broad. Is that correct?
Yes, I would agree with that
Okay.
statement. Concern would be, of course, when you go talking about requiring hospitalization, or treatment at a hospital or similar medical facility. And the question there is, what is a similar medical facility? You know, we've got these urgent cares, whatever you want to call them, first cares. You know, if it's on a weekend and doctor's offices aren't open, where else you gonna go than to a hospital, ER room, or one of those places? So it still may be minor. It may only take some stitches or you know, antibiotic shot or whatever it may be.
I understand, and I think that, you know, another concern that was raised is that injury might just be broad, is too broad as well. Somebody could
Yes.
be in the course of work, have a diabetic issue, or get stung by a bee and they might be allergic to bees, or they might twist an ankle, they might do something that's not necessarily in the course of, that would be, if you're an electric utility, necessarily something that you would think that's a hazard of the job.
Yes, sir.
You know, shock, maybe a fall from a bucket truck. I know we've had, you know, tree trimmers, contractors get hit by limbs and the like of that, and then those have been reported even though they're not shock or burn. So the question had been whether, you know, was the commission intending to really open up every single thing? And I speaking only for myself, and I think staff could back me up, that was not the intention, was not to expand it. It's just that there might be situations where there is an injury that is related to the course of work, like I said, a tree trimming accident, you fall out of a bucket truck, you're not properly harnessed in, like that during the course of your work, that should be reportable. That requires, you know, that's clearly, you know, not going to your second question, but does require hospitalization that maybe hadn't been reported in the past, like that. We certainly, because of the interest in this, I suspect that it will not, whatever is formally presented to the Legislative Research Commission would not represent what is here. We welcome your comments, particularly written comments on the issue. That way we won't have to worry. And I also know that comments will be posted to the website as well. So we'll know what it is, and let's see, Clark Energy raised this concern, and Owen as well. So we're aware of that. And I don't think that it will stay in this form. We'll try to make sure that it's clear enough in order to distinguish between that.
Well, one of the reasons we're here is just to understand the commission's intent.
It was not to create a new category of reporting. I think it was just to clear up what we thought might be some gaps. Just some injuries may not relate, there may not be shock or burn. That's it, but not expand it to, like I said, you get stung by a bee and you have anaphylactic shock or something like that. That shouldn't be something that's reported. You administer an EpiPen, you have to go to the emergency room. That would not be something that I think that the commission intended. Does staff agree with?
I think it was, and obviously there's a lot of people involved, so other people, you know, everyone might have different ideas about what a particular change was intended for, but it was, I think it was in the change from there was two changes really, the incident to accident. The incident was to cover basically something that might be intentional or something, but the injury, like Jeb said, was intended not to cover every possible injury, but to cover anything that might be. And I guess it's somewhat hard to articulate, which is sort of the issue with the language, but like Jeb said, like someone falling out of something that is work related or related to workplace safety that isn't the result of a shock or a burn. And how, if you do written comments, which would probably be really helpful, you know, if you all have an idea, and if a lot of people have similar ideas, you know, how to properly articulate that based on the type of injuries that you all would typically see that aren't necessarily reported, and you know what would be reported, because obviously we know what's currently reported, we don't know what injuries aren't reported. But if you all had suggestions of language and kind of an explanation of why that language would work the best, that would probably be the most helpful for the commission to make sure that it's covering the kind of, workplace safety issues that it's intended to cover, but not bringing in every possible, someone tripped on a curb and twisted their ankle or something like that.
And a good wordsmith can
Yeah.
come up with wording without being too lengthy, I believe, yes.
Yeah. And kind of explaining it too. That way, if we get like 6 different suggestions, we can kind of parse out, why someone might have suggested and whether or not someone else's language might suit what someone else was trying to, do with their language.
And I will say, a lot of times when we're sitting, I mean, we commission staff has reviewed every of our regulations, which is a tedious, process. I'm not bragging and not complaining. It's just a fact. And sometimes we'd get to a point, we'd say, well, we'll make this change, but this is really just for a conversation starter. And then we'll talk to the shareholders, and, there are some things in these regulations that nobody here knew why they're there. Phrases we don't even understand, probably especially from telephone. It was, relevant 70 years ago, but not anymore. So, but yes, that, to echo Ben's point, we very much welcome suggested language like that, so.
Well, to start a conversation, the next item, when it talks about property damage to 25,000.
Mm-hmm.
I did a little research on this a few years ago, and this amount was set probably, I can't really nail it down, but maybe the 80s, maybe even before that. And that was a significant amount back then. You could buy maybe 3 vehicles for that. Nowadays, of course, 1 vehicle will cost you more than that.
Mm-hmm.
So we'd like to ask the commission to consider revising that number. We feel like we know the intent, and we feel like this is probably, I don't know, you call it a little overzealous for 25,000, but got to think back what was 25,000 back in 1980 or whenever.
Mm-hmm.
Ben and I had this exact conversation in the hallway
Okay.
about the amount, and I think we welcome suggestions on that amount. Right, something, if any amount of money set in the 1980s probably has changed, whether for good or bad. So we shall see. But yes, we have discussed that. And the other change in here is the original regulation said actual or potential property damage. Well, some utilities read that as just damage to the utilities property and had not reported it, but others have said, well, damage to any property, and so we added that sentence in there to property owned by the utility or others. There's an example of that I recall that a water tank for a water utility overflowed and caused flooding down there, and they said, do we have to report this because it didn't affect our property? And we said, yes, you have to report that. So that's that clarifying language in there to reflect what the commission's always understood the regulation to.
There could be some comments also regarding who caused the incident, because it can be that, let's say a car runs off the road, clips a pole, clips a guy wire, whatever. Therefore, there you go, you get above that magic amount, whatever it may be, depending upon the structure, that can even be very expensive. So we may even consider, who caused the incident.
Right, so that's a good point, because if you go back to the very top here with section 25, it says of a utility-related incident, I could fairly see somebody saying, well, that means by an action or omission of the utility. It's related to an action or the omission of the utility. Water tank overflows because you don't have the proper equipment, that's the utility's fault. You have, say what you will, but if it's an action caused by, say, a car runs off the road and hits a water tank, causing it to crumble, or knocks out a pole and it would cause over $25,000 worth of damage. What if that knocks over the pole and it catches something on fire? That's a good point. Please, in your comments, bring that up so that we can consider that. I don't know how the commission has interpreted that in the past. So it takes some of our. I'll have to go back and take a look at that. But that's a very good point that I, quite frankly, hadn't thought about. Ben?
I know the inspections division, I think they're aware of whether or not utilities, particularly with car accidents hitting poles and it being $25,000, that person just totaled their car and, that's probably over $25,000 and utility pole costs X amount of dollars. So potentially that would have to be reported. And I think there is some awareness of that issue, particularly with the Division of Inspections. And I think particularly in this area, like the 25,000, it's not necessarily that anyone thought that that's really the appropriate thing. It's kind of something where we didn't change it, but, sort of expecting that certain utilities might request suggest that number be updated, and then we can evaluate whether or not that actually makes sense based on the reasoning that's given. So if you suggest a dollar amount, I would suggest that. And potentially too, if the dollar amount goes up, then, that could potentially take care of some of the kind of minor incidents with respect to, accidents into poles and things like that. I mean, if someone hit a water tower with their car and the water tower fell over and broke, then I would say there's probably an issue with the water tower, so maybe that should be reported, I don't know. But
People drive faster these days. It's true. But in that situation though, it's probably if there's going to be a loss of service or a large loss of service, that has to be reported.
That's right.
Under a different reporting requirement. So I mean, there's a few things that would be. I mean, I think that I don't know about the philosophy behind requiring somebody putting a money threshold on damage of property, or reporting it. It could be just to put the commission on notice. I mean, if there's large amount of storm damage, is that because that it's utility related. And a lot of times we will be put on notice about that because sometimes a utility will want to establish a regulatory asset, so they report it saying, I think Kentucky Utilities had their damage to their Brown plant in the storms that went through, and the first thing they did is let us know this is an anticipated amount of damage and like that. So anyway, good points. We welcome your comments on that. And thank you for bringing some of these questions to our attention. Like I said, when I said we would plow the same ground, some of the concerns we hadn't heard before on that. So thank you. Do you all I know you probably don't have many concerns about the general because it doesn't apply.
Right.
And not to you all. Are you all ready to move on to the pole attachment discussion?
I am.
Okay. All right, I'm going to turn it over to Ben, who can kind of go through. Then, I will stress once again, this is just an initial draft. It's a way to start a conversation, and we welcome any and all comments and input.
So I know if some of you all watched the video, but basically, kind of, the commission currently regulates pole attachments, and we have the regulation in 006, which effectively just says that cable TV providers shall be entitled to attach, and utilities shall file a tariff regarding pole attachments, and I think it might say something about complaints or something like that, about the timing of complaints. In part, that's because the federal statute with respect to complaints, I think, says it has to be 306. It has to be a reasonable amount of time, not to exceed 360 days, in which complaints have to be addressed. And so the commission's current reg includes the 360 days in which the complaints have to be addressed regarding pole attachments, and that's incorporated into this statute or this regulation. But really, a lot has changed since the commission's previous regulation was adopted, including the fact that the FCC jurisdiction over pole attachments was expanded to telecommunications providers, and they've interpreted that recently to also include broadband providers. Although elsewhere, they've interpreted that slightly differently with telecommunications providers, but that's what their reg. And so with respect to the investor-owned utilities, if the state isn't regulating it, then, potentially it's not reverse preempted and it falls to the FCC to regulate under their regulation. And I know it's somewhat different with respect to the co-ops, potentially. But the idea was basically to bring Kentucky's regulation kind of up to date. We have had some complaints. We had one complaint case like in 2018, I think, over pole attachments in Lexington. I know there were some issues with Kentucky Wire getting pole attachments, and then with the potential rollout of the 5G over the next several years, there's some anticipation of potentially being some issues with respect to pole attachments because they may need to connect to a number of poles, depending on where they roll it out here in Kentucky and what the effect of that is. So the idea was basically to kind of update Kentucky's pole attachment regulation based on some recommendations from the FCC and to kind of get people's input on what should be in there. So this regulation effectively, there's some changes to it, but in large part it is effectively taken from what's proposed by the FCC in their most recent regulation, and was kind of brought over to fit within the manner in which Kentucky regulates pole attachments currently, because the commission in the 80s regulated pole attachments as a service provided by utilities, and so has required utilities to file tariffs indicating the cost of attachment and things like that. And whereas the FCC doesn't regulate them in that manner, they require you to publish the costs and things like that, but they obviously don't require a tariff per se. So really what this does is it kind of requires utilities to file a tariff governing pole attachments, and the initial section 2, is just the duty to provide access to poles, and basically just says that a utility shall provide a cable television operator, telecommunications carrier, broadband internet provider, or government entity non-discriminatory access to a pole duct conduit. And that is taken from, or a variation on the federal regulation at 47 CFR section 1.1403A. So that's kind of like the general rule, is provide non-discriminatory access, and then there's some exceptions in section 2 or subsection 2 of that for safety, reliability, generally applicable engineering purposes. So it says, even though you have to provide access, notwithstanding that, a utility may deny access for any pole on a non-discriminatory basis where there's insufficient capacity or for reasons of safety, reliability, or generally applicable engineering purposes. And that's from the federal regulation too, basically. And the second exception there is with respect to easements, essentially saying that although you have to provide access to the poles on a non-discriminatory basis, you do not have to provide an easement. That's the responsibility of the attacher. Now, and I think the intent, the FCC reg doesn't really address that, but there has been some cases basically saying that if the pole owner's underlying easement would allow for the attachment, then they would allow for the attachment. But if the pole owner's underlying easement wouldn't permit it, then the pole owner doesn't have to go out and get the easement on behalf of the third-party attacher. That would be the responsibility of the attacher to do that.
And I think that's consistent with the opinion letter the commission issued. I think it was a request from the Kentucky KCNA regarding what the liabilities or the property rights for regarding the underlying easement, or is that the cable attacher takes the easement as the utility has it. And if the easement doesn't allow for the connection of broadband or well like that, it's on the broadband provider to negotiate with the property owner to get it, not the utility.
And that's the intent of that subsection 2B there, is basically to say that explicitly, because in the FCC, it's kind of led to some litigation, and so we were just trying to preempt that and specifically say it. And so that's the general thing. And then the other thing is like you have to file a tariff with the rates and things. That's all in that general section. And so it's saying you have to provide access to those things. The one caveat is it's not saying you can't provide access to other parties necessarily. So, you know, if a utility's preparing its easement or preparing a tariff, you know, if that's all you want to provide access to, all that's required by the reg, you know, you would want to be careful to, you know, limit it to those parties. But the next section is just saying, section 3, that you need to file a tariff governing the terms and conditions of attachments. And it does mention in there that the tariff may incorporate a standard contract license for attachments so long as the terms are consistent with the regulation. I will say the purpose of that is most utilities already require, you know, there's a pole attachment tariff and then there's a licensing agreement generally that most people will require people to sign. This is intended to, not that you can't have the license agreement, but that you would incorporate it as part of the tariff. And then that would be a condition of service that people would, in the tariff, be required to sign in order to gain access.
Is this encompassing, or is this an attempt to encompass not only cable TV and broadband providers, but also telephone companies?
Well, it did put in there, there is another exception in there. Well, let's see. So in some ways it is, but and there is an exception above, and maybe that needs to be a little bit edited, but so there's the procedures for attachments down below. And I guess we were trying to exclude joint use agreements. So like if you have a joint use agreement with a telephone company, then those were, I think the intent was to exclude those from this regulation. In part, I mean, I don't know if it necessarily be excluded. I mean, you would still be providing them access. So you would, under the current regulation or as proposed, like you would still have to provide telephone companies access to the poles. Now, where the difference would come in is the non-discriminatory. And I think the idea in part is that if you have a joint use agreement with a telephone company, that they are not similarly situated to a telephone company that you don't have a joint use agreement with, because the joint use agreement, you're basically, they're putting stuff on your poles and you're putting stuff on their poles. And so that would be governed under a separate joint use agreement. Whereas if it's a telephone company or a telecommunications carrier coming in to which you don't have a joint use agreement with, they would be able to attach, but they would be attaching just like any other party as a new attacher.
Let me ask a clarifying question. Are you when you ask about a telephone company, are you thinking about the incumbents, or are you thinking about something, one that has their own poles?
It could be either.
Okay, all right. Because I think that, in what Ben was saying, if you had a joint, you probably do have a joint use agreement with some of the telephone companies down there. I don't know exactly how Meads overlaps with the different cooperatives, or if it's AT&T. I think
We have
Brandenburg.
some AT&T, we have Brandenburg Telephone Company.
Right, and so
Mainstream or whatever they are now.
they're still, well, no, I guess the poles are owned by Unity or something. It's their real estate investment trust, but yeah, you've dealt with it, yeah. whatever it is. I don't
You
think,
said it right.
yeah, whatever it is. Yeah. So it would be my understanding nothing would prevent those joint use agreements for continuing, if you have those. You know, part of the reason this regulation is probably due is that back in maybe 2003, 2004, there was a complaint case between Ballard Rural Telephone and Jackson Purchase. And the issue was pole attachments and the rates and conditions of service and like, because at that point, you know, the commission had only addressed in their regulatory orders CATV attachments, and the regulation only applied to that, and the tariffs of all the cooperatives, all the utilities probably dealt only with CATVs. And there the commission said, well, go try to figure it out yourself. But if you can't, you're going to come back in here and Jackson, you're going to have to file a tariff with us and with the rates for pole attachments for telephone companies. And slowly but surely, the commission's looked at pole attachments and has expanded it, not just for CATVs, but as well determining that just the use of the pole is in itself a service. So, you know, that's one of the reasons why we're coming to this, the pole attachment reg, because it's been either done by complaint in the, you know, Jackson Purchase. We have half a dozen opinion letters out there, and just, you know, a lot of informal conversations with the utilities. And so, yes, it would apply to telephone companies, but, you know, you might differentiate between whether or not they're one with which you have a joint use agreement versus one that doesn't have facilities besides their lines.
And that would fall under, so the duty to provide access, like, it doesn't really distinguish between people or utilities to which you might have a joint use, like a pole-owning telephone utility versus a non-pole owning. It just says you shall provide non-discriminatory access. But in part, I think the intent is that the recognition that providing that those utilities are not similarly situated if there's an exchange of access to poles. And so providing somewhat different terms to a joint user or a telephone utility to which there's a joint use agreement, that it wouldn't necessarily be not discriminatory to provide them different terms than a utility to which you're not sharing poles. But and perhaps that language needs to be tweaked, I don't know. But then with respect to Section 4, which governs, because Section 2 and 3 just kind of set out the general rules, like you have to provide non-discriminatory access, you have to file a tariff or a special contract indicating the terms of the attachments, whereas Section 4 specifically sets out the procedures for attachments and how, you know, potential new attachers would be able to request attachments to the poles. And if you look at Section 4, it always refers to new attachers, and up in the definition section, new attachers was written to exclude attachers for which you have a joint use agreement, so that those procedures wouldn't apply to utilities to which you have a joint use agreement with. It says new attacher means table or requesting except that a new attacher shall not include a utility with an applicable joint use agreement with the utility that owns or controls the pole to which it is seeking to attach, or a person seeking to attach macro cell facilities. So it was explicitly excluded that the attachment of these kind of expedited procedures in Section 4 wouldn't apply to utilities to which you have a joint use agreement with, or to the a person attempting to attach a macro cell facility to a pole. And the Section 4 is really the bulk of the regulation in that it sets out really specific procedures for how to handle, or how a pole attachment should be handled, with applications being filed and applications for pole attachments, you know, being filed. Those have to be addressed for completeness and then in substance within a certain amount of time. The make-ready work then has to be completed within a certain amount of time. And then payment for, and it also covers payment for the surveys and for the make-ready work. And allows for utilities to request security or demand prepayment of the make-ready costs. And then requires at the end for the utilities to send a bill for the actual cost of the make-ready and the survey work, to the extent they differed from the initial estimate. So with the idea that the make-ready and the survey work that a pole attacher might be requesting, that those costs would be covered by the potential attacher, and that, so that they wouldn't be borne by the utility or the utility's other ratepayers. And also with the idea that the utilities would be able to request or demand payment for the make-ready work ahead of time, so that you don't make these changes and then you have an attacher, you know, maybe an unknown attacher who ends up just kind of leaving and not actually attaching and never actually paying for the make-ready work.
These procedures, are they, do they emanate from the FCC, or were these procedures devised just from some general wording from the FCC?
So they pretty much come straight from the FCC.
They did.
So if you look in section 4, so section 4 is the main like attachment procedure. If you wanted to look at the FCC regulation, it's 47 CFR section 1.1411, and you can probably kind of go through. It's effectively in the same order and laid out in a very similar manner as that regulation, but section 4 matches up to that regulation. Not word for word. There was a number of changes, for one, to fit it within the commission's regulatory structure. But, and there were some changes to take some things out that, you know, perhaps either didn't make sense in Kentucky or didn't necessarily make sense. And perhaps maybe someone might want to put those back in, I don't know. But just one example is, so under this proposed regulation and under the FCC regulation, you get an application, someone wants to attach to your pole and you get an application in. Your tariff, you know, you can put in the tariff, you know, what would be required as far as what you need from them in order to accept an application. You have 10 days to determine whether or not they've actually provided the information, like whether the application itself is just complete. Like, okay, they've identified the poles they want to attach to, they indicated what they want to do, whatever your requirements are. You know, they've told us, they've told us the poles, they've told us what they want to do, they've told us what they want to attach. And just looking at it, okay, they've provided this information. Now we have information where we can actually substantively review it. And under the FCC reg, you had to do that within 10 days and send them something, not necessarily send them something, but you had to inform them that it was, if you determined that their application was incomplete, you had to do it within 10 days. And if you didn't, it was deemed to be complete. So one change that we had here is that we still kept the 10 days, indicated that you need to determine whether or not an application is complete within 10 days or not, but we removed the provision indicating that it was deemed to be complete if you did not do it within 10 days. And in part, the reason for that was because there was concern that if someone, 10 days is kind of short, and if, say, like you're 1 day late and they didn't identify the poles properly and it's deemed to be complete, now you have 35 days to substantively review it, but you actually don't even have the correct poles, that could be somewhat difficult. And so the idea was that you're supposed to do it within 10 days. If you are constantly missing the 10-day period, then, you could potentially be found to be willfully violating the regulation. But if you just through inadvertence, on one occasion, miss it by a day or two, then you're not going to have to review an application without actually having all the information in there. And so that's like one change, but generally, this does track the FCC regulation. And if you go through the FCC, and including the time periods, and like Jeb said, it's kind of, and the FCC regulation has a two-part process. Like there's the one process where you would send the application to the utility would review the application, do the make-ready work, or get the other attachers to do the make-ready work. And then then the new attacher can attach. And if you don't do it within that time frame, the new attacher can seek self-help, and there's a procedure for listing contractors who can do the work, and they can go get one of those contractors to do the work if it's not done by the utility in a timely manner. And that's in here. All of that's in here. But then the second procedure, which is kind of a new addition to the FCC reg, is the one-touch make-ready, which is separate from this, what would be an expedited, or not necessarily an expedited, but basically an established procedure for handling attachments. The one-touch make-ready is an alternative that a potential attacher could elect to use, and it kind of has, it can be only used in certain circumstances, generally for simple make-ready, and it kind of has similar timelines, but they're more expedited, and it basically allows for the attacher to use the self-help almost immediately. And so both of those are included in here, and both of those are in the FCC reg, and a lot of the timelines and stuff were kept the same, but like Jeb said, it was intended to be a kind of a starting point for a discussion, because otherwise we wouldn't have had any place to start. And so, that's why we kind of started with the FCC reg, made some adjustments here and there, and then with the expectation that we'd be hearing from people regarding, the timelines, whether or not one-touch make-ready should or needs to be in there, whether or not, it shouldn't be, and the other procedure should only apply, and, the timelines, should be adjusted or shortened or lengthened, and things like that. So that's basically the layout of the regulation.
One of the concerns, most of this is really playing and regulating us utilities. And I guess you'd say holding our feet to the fire. But since we're talking about everything from safety to doing it right, is there anything here to hold the attacher's feet to the fire?
Because we only have jurisdiction over utilities, we would be somewhat limited with respect to attachers. But where you would hold the attacher's feet to the fire, I suppose, would be in the conditions that you establish for attachments. So the regulation contemplates you having a tariff, that would set the terms and conditions of attachments, but also permits you to have an agreement that you would require attachers to sign in order to be permitted to attach. And one of the things that specifically put in here, if you look at section 3, pole attachment tariff required, and there's some utilities, LG&E has a really extensive pole attachment tariff already that incorporates a lot of the FCC stuff in there. And they have really detailed terms, including, and then a license agreement that people are required to sign that's kind of based on that. And this term actually came from a Vermont regulation, which the FCC regulations are somewhat based on, or they were back in 2011. But Section 3, paragraph 3, it says a tariff may include terms that are fair, just, and reasonable, subject to approval of the commission, such as a limitation on liability, indemnification, and insurance requirements, restrictions on access to utility poles that are consistent with the requirements of this administrative regulation. So a lot of utilities and maybe even your all's current license agreements have clauses in there that require the attacher to indemnify you for any loss that they cause, or to maintain insurance, which in any commercial lease, generally there's going to be a indemnification or insurance requirement as part of the commercial lease. And so, the idea with that Section 3.3 is to permit terms subject to commission approval, such as, requirements that the attacher maintain insurance of X value, so that if they do something that causes, and permitting indemnification, such that if they do something that causes the utility to be subject to liability, that the utility would have recourse against the attacher through the insurance or the indemnification provision in the license agreement. And with respect just generally to safety too, that's like after they attach, and is the utility going to be made whole by something the attacher does wrong? But on top of that, there's the in Section 2.2a, and this is just straight from the utility or the FCC regulation. The general requirement is that you have to provide these. The general requirement in Section 2.1 is you have to provide cable television operators, telecommunications carriers, broadband, government, non-discriminatory access to the poles. But then the exception is there in 2, which is notwithstanding that, a utility may deny access to any pole, duct, conduit, right-of-way on a non-discriminatory basis where there is insufficient capacity, so there's no room on the pole, or for reasons of safety, reliability, and generally applicable engineering purposes. So that would give the utility, that would come really at the survey stage. So like you get an application, if you're going under Section 4, you get an application in, and the survey is basically you all determining whether or not, for one, what do you all need to move around? Like if there's other attachers, do they need to be moved up or down in order to fit someone else on there? And then 2, part of the survey requirement is, can this attachment actually be made, physically, or from an engineering perspective, or from a safety perspective? And this would, if the determination is made that it's not possible for, safety, reliability, or generally applicable engineering purposes, the utility would have the discretion at that point to deny the request for attachment. And that would come, the exception is there in Section 2, but the review process, that would come at basically the survey stage, when you're getting the application in and reviewing what they want to do, and basically going out and checking the polls and being like, okay, well, wait a minute, that's not going to work, and then you would deny it. And, if there was an issue, if they thought that the denial was inappropriate, and there is a requirement, I think, even down in Section 4 where it kind of goes through the procedures, if you do deny, like it does say you have to give them the reason and an explanation for the denial. And then if they dispute that, then their recourse would be filing a complaint with the commission, basically, to resolve it. Or working with you all, to find some other way, to, either going in a different direction or,
Paying to put a new pole in.
Yeah.
Paying the cost of it.
yeah.
I don't think the idea is to impose a cost on the utility.
No.
on this, and to protect I mean, at the end of the day, commission is charged with making sure that utilities provide utility service safe, safe and reliable manner, reasonable rates, and, I don't think that anything that the commission's proposing here to do would be intended to be counter to that.
Yeah, the intent is to put the cost on the attacher for any costs that the utility incurs due to the attachment. Or even handling the application for the attacher. Because that's similar with any utility customer, that the particular customer, generally, you try to align the cost with the customer that is requiring the utility to incur the cost.
This may also require an update to pole attachment rates. I don't know about Meade County, but I know that several cooperatives you go out there, that the rates are those that might have been filed in 1988. Pole attachment rates are not going up. Mr. Hendricks, have you had any experience with the cooperative rates, or do you know?
No, it's generally whatever the rate they give us is, what we work with. And,
Okay.
and they move around.
The big gap in this is going to be the municipals and the TVA cooperatives.
Because they're not subject to this
Nope.
unless we have a complaint case that we can then bring against them, but not the TVA. That goes to TVA, I think, doesn't it?
Yes. I think we addressed that issue, just federal preemption issues.
Right. 'Cause there's a case that talked about that recently,
Right.
wasn't there?
There is some more safety stuff too down in section. So, with respect to the one-touch make ready and the non-one-touch, the two procedures, there's the specific procedure where the utility does the survey and the make ready, and then there's the one-touch make ready. And both of those allow for self-help at some point. So even in the first procedure, if the utility doesn't meet the timeline, then the attacher can exercise self-help. And the way that you would exercise self-help is using a contractor, that the utility would be required to maintain a list of a contractor who would be authorized to do work. And that's in section 5, and it's somewhat, there's two types of contractors. There's contractors doing simple work and work above the communication space, and then contractors doing complex work or work above the communication space. And then there's the procedure that would govern contractors doing simple work. I think it says simple work. That might need to be changed to simple work or work below the communication space. Or no, I'm sorry. That would just be the simple work, because complex work could be there could be complex work that's below the communication space, actually.
So is that term simple work is an undefined term?
It's actually defined above.
Okay.
It's based on the FCC definition. Well, actually, complex work is defined. I don't know if simple work is, let me double check. Would be anything that's not
Simple
complex.
make ready, is that what you're talking about?
Yeah, so it is.
It's section, it's the last
Simple make ready.
section of section 11.
I couldn't
Section
remember if
1.
it was defined as anything that's not complex, but it is specifically defined.
So like in that last section you had up where it said simple work, you really mean simple make ready, right?
Yeah, that might need to be, changed to just simple make ready. But, there's procedures for listing the contractors, and then there's procedures for the utilities for the attachers to request that new contractors be added to the utilities list. Because as I understand it, in part, sometimes contractor availability is an issue, even for both parties. I mean, even if the attacher wants to exercise self-help, if they're doing a lot of attachments, there might not be the contractors available in a particular area. So there is the option of the attacher suggesting an additional, and it requires the utility to look at them and see if they meet the safety requirements. And the down in section 5 subsection 3, it has like the minimum safety requirements for the contractors, or the minimum qualifications. And it includes some safety requirements in there with respect to contractors. And I'm pointing these out in part just so you all can know where they're at, and if you think more needs to be added or things need to be taken away, then you know where they are and what we were looking at.
Does it have a rate-making provision in it? Because I think in the establishment of the rates was originally set up through a commission order.
It was, and that formula is still intact by
Still
a
in-
commission
it's by
order.
But it's not set forth in this regulation.
No.
Okay.
Because I think because it was set by administrative order, the idea is that it could be amended if necessary. I mean, the idea is that it's a cost recovery.
Right.
You know, you break down the
Standard
cost
rate-
per
standard
foot per.
rate-making.
Right, per cost of pole. I remember Kelly Knuckles from Jackson Purchase lamenting that he could look over at Paducah Municipal and they were making so much money off their pole attachments, why couldn't he? And said, sorry, Mr. Knuckles, but it's the way that the regulation is, it's cost-based per foot. But to your question, Mr. Hendricks, I don't think that we need to put the rate-making mechanism in there. It'd be somebody come in, if they want to increase their rates. I don't think that the cost of a pole has gone down since the rates were, whenever the last rate case it was that they established the pole cases. And, we have established a streamlined rate case procedure for cooperatives that, the commission will attempt to turn around a rate case for cooperatives within 60 days of filing. It's not guaranteed. It's not guaranteed that a utility or cooperative would qualify for it, but the intent was to diminish the cost. I don't know if you all are familiar with the procedure for that. I don't know when Meade County was last in. I think there's for a general rate case, there's a 10-year, if you haven't been in for a rate case in 10 years, you can't use the streamlined procedure. But it'd be something that could be utilized, I think, or the pole attachment rates could be rolled into that proceeding. I don't think you could use it so simply for the pole attachment rates, because it would be single issue rate making, but as part of a general rate adjustment, it could be
They can
included.
be done at the same time, though.
Yeah,
Yeah.
exactly.
That was gonna be my next question. So-
Right.
And it's not explicitly in here, it's technically covered in section 3, in that it just says, a utility that owns or controls utility poles located in Kentucky shall maintain on file with the commission a tariff that includes rates, terms, and conditions governing pole attachments in Kentucky that are consistent with the requirements of this regulations in chapter 278.
Right, so probably what would have to happen depending on how or if this regulation goes into effect, is that the commission would probably open up or maybe send a letter out to the utilities saying, please update your tariffs. Because a lot of the tariffs said, the terms and conditions came about in '85, whenever the first Supreme Court case wrapped up. We did the same thing with the electric utilities, sending out letters reminding them to update their net metering tariffs to comply with Senate Bill 100. So it'd be one of those things where
And there is one thing that's not addressed in this regulation, the draft, because this was really just to draft like the actual requirements, and this is something that came up at some of the other meetings with respect to, not necessarily this regulation, but some of the other changes, is an implementation period. And, because if you're gonna have to update your tariff to make it consistent with this, I don't necessarily know that, we would want every single utility filing a tariff the day after
At
this.
the same
thing.
day?
Yeah.
that
So-
guy right there, Mr. Hinton, certainly does not want that. He's the one that would.
So although it's not actually in here, we do anticipate some sort of implementation period, and I think it would be good to have people's, thoughts on that. Whether it's, file it when you file your next rate case, so long as you do it within, a year or whatever, I don't know, but,
Well,
but
the
some
tariff
sort of
can be-
implementation like that. And another thing that doesn't necessarily cover it is, because you have the joint use agreements, which are effectively in large part exempt from this, or intended in part to be. But you don't, but it doesn't necessarily also cover, because a lot of attachers are currently operating under licensing agreements that are not joint use agreements. And there are some of the other states, when they've done this type of update, have put something in there that said, you know, that it shouldn't affect those contracts until they expire or something to that effect. So if that's something that people think would be appropriate, you know, I would suggest that as part of discussing the implementation of the regulation.
And also, I think a question that we have received is, does this also apply to transmission? I know that, you know, for the distribution co-ops, it may not be an issue, but, I mean, it's my understanding it would only apply to the distribution system of a utility. So, a representative from East EKPC had that question last week, just want to bring that up.
So in that situation, it's sort of a one-on-one deal,
If they
right?
wanna, they can. And if they wanna allow it. I mean, is that accurate?
Well, it's actually not explicit that it doesn't apply to transmission lines. And I think in part that's because you would then have to define what is a transmission line versus a distribution line, which I think some people might dispute what's what in some ways. But you know, obviously it has the safety thing, and if it's a high voltage transmission line, then you would have a stronger argument as to safety with respect to the use of the pole.
It may not be a pole, it could be a
Or- oh,
tower.
yeah.
That's,
And pole isn't actually defined, so, you know, that could be something that if people have a specific thoughts on what should a pole actually be, you know, that, you know, I think would be potentially something where that could be addressed with respect to what it would attach to. But the safety thing is really, at this point, where the way it's currently written, you know, it's not explicit, it has the exception for safety, so it doesn't explicitly not apply to transmission, but
that could be covered in a tariff quite, I mean, I haven't looked at Meade County's tariff, but, you know, most of the tariffs have, you know, basically allowed for attachments to 2 or 3 party poles. You know, 1, 2, 3 party poles, and they'll have different rates and guy wires, but it doesn't have the availability, didn't list the availability of transmission facilities.
And I think that is that, because like some utilities might want to allow that actually, and you could put the terms and conditions as long as it's non-discriminatory in there, and you know, then it would be reviewed. The basis for the review, you know, the commission would look at like, okay, why did you do this here and there, and and that's, you know, also goes to the, you know, requires provide non-discriminatory access to those 4 types of entities, which are really the 3 that the SEC requires, except we spun out broadband into a separate one because the FCC includes broadband as part of a telecommunications provider, but also doesn't in other areas. So just to alleviate confusion, we have them separate. And then we also include a government entity, which the FCC doesn't include. And that's in part to ensure things, you know, government-sponsored broadband or things like that. And
Such as Kentucky Wired.
And there are, I mean, I think some universities actually might have pole attachments, if they're larger universities.
Well, some public school systems have. I know
As I say, they're public school systems.
Jefferson County has. I know that way back when Laurel County was looking into it, the like of that. So, you know, there's be a lot of different reasons with people wanting need pole attachments. It wouldn't be necessarily they'd be providing service to the public. It could be for their own use. And I understand that the FCC might open up the 6 gigahertz spectrum that, you know, for I guess just, you know, whatever use besides limiting it, that the electric utilities may have to install their own fiber optic systems because of the idea that the use of that was, I guess it's a 6 gigahertz spectrum might mess with the SCADA for some utilities if they're using wireless communication for it. So, you know, it's I remember when I was in law school, the saying was, I was taking a class in banking law, that banking law was always, the new laws were always 2 crises behind where they really need to be. And so, we're trying to anticipate things that can pop up, with this pole attachment regulation, but, the FCC sometimes is a few more steps ahead, so there'll have to be some flexibility in tariffs and and I think that, the very end, is there a deviation section from this?
I don't believe so.
Okay.
No. And I think the idea is that, because really, with respect to anything other than, the main explicit rules in here are the procedures for handling attachments, and, we wanted that to be uniform. Everything else, because all of the rates, terms, and conditions of service and things are gonna be governed by the tariff, then there's automatically built-in flexibility there, because you can put what you want in there, and that would be subject to the commission's review. And to my point about the 4 entities that have to be provided non-discriminatory access, sort of to Jeff's point about, the tariff indicating what poles can be attached to, you have to provide non-discriminatory access to those 4, but it's not necessarily saying you can't provide it to others, or that in your tariff you limit it to certain entities, and then the macro cell is specifically excluded from the attachments with respect to the expedited procedures, but that's not to say that you couldn't permit macro cell, under, just by entering into a contract with people with respect to, the attachment of macro cell facilities.
Has Meade County had any requests to put on, the small cell, the DAS or anything on your poles? Okay. I think that it's primarily Louisville and northern Kentucky where we've seen that those issues pop up. So. And that's, has always been a cause for consternation too, because you have an attachment above the utility space, and then you might have a wire going down on a meter, nailed into the base of the pole too, so.
Yeah, I've mentioned this at the previous meeting, but like I've seen like the small cell like at the top, and then they have a wire coming down from the power line, like through some sort of tube or conduit on the side of the pole, and then next to it, on like drilled into some sort of apparatus, is a meter provided by the utility. The wire goes into that, and then it goes back out and back up to the small cell cellular at the top of the pole. Which, I think there's 1 or 2 now, but whether or not people will start raising an issue with those things on the side when, they're every 200 yards, I don't know, but, or however often.
Did they jet out of the easement or right away? I mean, that's not an issue for the commission, that's local law. So to the attachers, I'm looking at you too, Ms. Call and Mr. Hendricks. Do you have any comments on this right now, or any questions?
Not right now. I mean, you've answered most of the questions that I had coming in.
Mm-hmm.
See, like I said, when we were looking at what you were doing, intent with the multiple meetings and things like that, so, I'm sure we'll have some written comments.
Okay, and like I said, next week we'll probably have it set up so people can participate remotely. We'll establish a bridge line so people can call in, because I know that, like I said, I've received an interest from parties that probably don't want to travel here from Atlanta or Washington DC, or at least.
And then, may I just ask a couple questions just about the process going forward? And I do
course.
want to just commend you all for having such a transparent and open process. Thank you so much for that. There's another meeting tomorrow similar to this?
Yes, ma'am, starting at 11.
Okay, and that will it be pretty much the same format, just depending on which stakeholders show up, about what the agenda will be, whatever they
Yes, ma'am.
want to talk
What do they
about?
want to talk about? We were able to cut out a good hour and a half or hour 45 minutes, but not discussing a lot of those
Yeah.
other regulations today.
Okay.
So, and, it's interesting to see what people want to discuss. And I mean, I really do appreciate your input, particularly when you bring up issues I haven't even thought about. So,
One of the, I'll tell you, one of the concerns we see at this very time, on some of the timeframes, is, well, when I say for right now, it's because it seems like we've been inundated in the last year or two for attachments. And when you get one right after the other, it really, when your staff is this much, and when this all takes place, all of a sudden you need this much staff, it's hard to meet those timelines that's set in here. So I guess one of my concerns will be some flexibility. And I know you talked a little bit about some of that flexibility earlier, but that's one of my concerns I see. Who knows, 5 years from now, it may level out, won't be any, but
Once everyone's attached with all the new equipment.
yeah, right now, I don't know, we've got about two that's on the line. I say on the line, I mean on telephone line, talking to us, wanting to get on or contemplating it. I know Kentucky Wired, they're in process right now. So it's concerning when your staff is set.
I think, and that's why I mentioned, like, we used the timeline and the numbers from the FCC reg and didn't change those. I think with the expectation that we would hear from the various different parties, including the attachers and the utilities regarding that issue. And I think it would be really helpful, for people to explain, how many they think they could do and why. For the utilities, explain, we can do, this amount would be reasonable. And there is some automatic limitation there, like based on the number of poles you have. So there's a maximum number and then there's a limitation based on percentage of poles, and it's the lesser of those two. But I think any explanation that, the utilities could give regarding, this would be our capacity and why, and then, for attachers, this is what we think, would be a reasonable amount, in a given period, or why we would need this many. And also, like, for the attachers, and I know people would want to get authorization to attach, like, as quickly as possible, but, at some point too, there might run into even if you're building out like a really large expansion, how many, if we get authorization to attach, how much of that can we actually do within that period? And, should the application number match more closely, and kind of explaining, the position on that would be helpful.
I would say as an attacher, I think the easy button on that is self-help. As long as we're able to come in, if a timeline's not gonna be reached because staff's not there, and we can come in and we can, we have people that meet the guidelines, the construction guidelines, the experience, the insurance and all those kinds of things. If we can do that, that alleviates the need of a utility to have to staff up, or to say the fact, I got two guys. What do you want me to do? So,
Well, it's not the make ready as much as it is the engineering and everything else that goes in behind
Right.
it.
The survey work, basically, is what you're talking about.
but I think there's this reg, if it mirrors the Fed one, there's a self-help on that. I mean, like, our guys will submit make ready engineering up front and those kinds of things. So, I think there can be some give and take in that.
I did misspeak earlier, because Jeb mentioned deviation. I was thinking most of our regs have a deviation section at the end that allows any deviation. Like, it's just a general, if you can show good cause, we'll grant a deviation. There is actually deviation from the timeline in section 4, subsection 8, but it's a very specific as to when you can get the deviation. And again, the point of that is basically that, so we don't have have the reg, and then every person has a completely separate
Yeah.
deviation from
Is it a
it.
size deviation? So like,
Well, there's the size deviations too, but then this is, the deviation is, this is from, effectively from the FCC. It's basically very specific. There it is right there. And I say it's from, there are some edits, so I mean, I wouldn't rely on it being word for word identical. Did anyone have any other questions about it, or?
I guess I'll have one more.
Yeah.
And I realize this came down from the FCC. These are rules and regs by the FCC. But, of course, there's many entities out there that are not FCC regulated. So because of that, why did the FCC feel like, they needed to get involved when everyone is already regulated with it?
So, just to clarify, there is a statute that requires, or that allows the FCC to regulate pole attachments, and that statute basically says if the state decides to regulate pole attachments, that the FCC's regulation is preempted. So, the FCC, it doesn't regulate pole attachments. So, if the commission has been the entity that's been regulating pole attachments in Kentucky, if the commission were to, completely withdraw its regulation of pole attachments, then there would be no regulation in Kentucky, and the FCC rules would automatically apply to utilities.
Except that it does.
Except-
Yeah.
Yeah, it would be basically the investor owned and others, but the FCC regs wouldn't necessarily apply to the co-ops.
They don't apply to utilities that are cooperatively formed. There's specific language in the FCC regs
But
to say that, or statute.
even with the FCC, so this commission can preempt the FCC regs by regulating itself, but the commission is not bound to use the exact same regulation as the FCC anyway. So this is based on the FCC reg as a starting point, but the commission is not bound to use the same language or the same format or anything as the FCC. It's just,
Okay.
And the FCC has encouraged states that have reverse preempted, which is what Kentucky has done. 22 states regulate pole attachments, and the rest the FCC does. But the FCC has written to each state that is reverse preempted, encouraging them to adopt pole attachment regulations that they haven't, and have, I guess, provided almost a model regulation, which is what it is. So they've encouraged, at least as a starting point for the states. Does that answer your question a little bit?
Yes, it
Okay.
does.
and the reason they're encouraging it, because that was your other question, is why are they doing it, is because they're trying to encourage the proliferation of broadband internet throughout the country, and 5G. They know that that's supposedly coming in the next, I don't know how many years, and they want these regulations to be in place so that those attachers will be able to attach. And I guess some of those entities that do provide those services are more likely, or have been, I think, more likely to come to areas in which, there is more access to poles, where they don't have to worry about being bogged down in, complaints all the time. But
That's, Mr. Hendricks, just a general question to you and your client's experience with pole attachments. What have been some of the sticking points? And does it differ from entity to entity as well?
it does differ, it did differ from entity to entity. A lot of our problems early on was in the actual negotiation of the pole attachment agreements. As a state agency, we're just not something that people are used to seeing. People get really hung up on the fact that, we're not gonna indemnify you. We're prohibited from indemnifying you, so we would spend a lot of education time on those kinds of things. We understand that, we're a big rock hitting the pond, because we're statewide and we're hitting a lot of poles, 80,000 poles or something statewide. I don't even have the number off the top of my head, it's a guess. So we knew we were taking up a lot of bandwidth that way. So it's the make-ready engineering and resistance on self-help. We got a lot of resistance on, we'd say, well, just let us do it. We got an engineering firm, we got a construction firm, we've submitted you the plans. Just, if you don't have the time to do it, let us do it. There was resistance in those areas, and,
I mean, understandable.
it's understandable. I mean, it's my pole, it's my equipment, and, do your guys really know what they're doing? I mean, it's a fair concern, so. But those were the two big ones for us. And a lot was just quantity. We're doing a lot, in a very, very short period of time that you're not gonna see generally with other entities,
And
not to our size.
We have an open docket with a complaint from MetroNet. They're rolling out broadband in all of Lexington against Windstream, and the issue really was primarily timing.
Yep.
Because they had one person would go around, Windstream would have basically one person to do the pole survey, and it would just take a long time, and then, you're never gonna be able to put it on fast enough for the attacher. I think that's what it came to.
I think the timing is the main issue. That's why the reg really only spells out specific requirements with respect to timing. A lot of the other stuff is left to what you put in your tariff. And I don't know if, you can answer this in a comment if you want or not at all, but I would be curious about the indemnification, because, if it's a government entity and can't indemnify, I mean, can the contractors indemnify the utility?
Yeah, contractors can, we require our contractors to carry insurance. That's what we would tell Meade County, for instance, if they said, well, you need insurance. Well, okay, our contractor will do it, because we don't, it's all contracted out. We don't have staff ourselves that goes out and does it. We don't have crews. So we hire a contractor. Our contractor carries a commercial general policy of a certain amount. I can't remember the number off the top of my head. But so they have that person they can get a hold of if they do something incorrectly or tear something up. And our contractor understands that. So that's how we do that.
In regards, Mr. Poe, what you said about staffing levels, I know that it has been a lament, particularly the cooperatives, just to find, I don't know if it'd be a lineman that would do the inspection, or the pole inspection or not, but just finding qualified personnel to work on poles has been a challenge. I don't know if it's affected Meade County as much as the ones in eastern Kentucky, but,
Our engineering part, actually taken care of by department headed up by Mike here.
Okay.
And, but as far as actual work, a lot of that's done by our contractors.
Okay.
Our physical contractors. And that's usually not that much of an issue.
Okay.
It's the engineering. And what we've always asked, just like we did with Kentucky Wire, is it was to help speed the process, is that just come meet with us, we'll go out, we'll take a day, half a day, look at it, and then a lot of times you can cross a lot of stuff off the paper by doing that. But that's where a lot is falling, because you got a lot of entities. I hadn't even worked with charter, but you mentioned people like in Atlanta or wherever. A lot of times, so often they'll want to work from Kansas City, Atlanta, whatever, and they don't want to do that.
Yep.
So it draws out the process.
That is a good point. When we would run into problems, that's what we would do, is drive outs. We get somebody in the truck, you drive the route,
Yeah.
and you can see what's going on.
Yeah, meet with this fellow
Right.
right here, and and that's the kind of thing that, we'd love to have that cushion or that ability to do in these tariffs or these regs, if possible.
Well, I mean, even if it's not in the regulations, you could submit it in your tariff.
Tariff.
The commission could review it, and if they found it reasonable, allow it.
Okay.
I won't speak for the commission on
Yeah.
that, but I'm saying you can ask for anything.
Yeah.
I mean, whether the commission says yes or not is a different story.
And I know every entity, whether it be a attacher or utility, does things just a little different.
And, you know, I was going back, and I don't take this as gospel truth, going back to the resetting of rates for it. There is procedure under the streamlined rate case that allows for a revenue neutral case. So, it'll allow you to, basically change your rate design. And I don't know if you needed to adjust your pole attachment rates, if that would be something you could utilize versus you doing a general rate case, whether it's streamlined or otherwise. That's up to accountants and lawyers, but I forgot that there is a streamlined procedure for non-revenue cases. If you're not increasing your revenue, but you're just changing the allocation among customer classes like that, I don't know if that could be used as well. So, something to consider. And if this pole attachment reg goes out in any sort of way, shape, or form as it is now, I mean, there might be changes. It'd be something that the commission would probably address, maybe even an administrative case, about how to, for the adjustment of rates or the modernization of rates or that for the utilities.
And it could be addressed in an implementation section of this exact reg. If
Right, it just,
if people thought there needed to be a procedure, because there's also a procedure for filing a tariff with a non-recurring fee, which technically, certain costs would be a non-recurring fee. But, if you were going to implement this reg and say people had to adopt it within a year or 6 months or whatever it is, you could also put in there a procedure for
right.
filing a tariff without having to file an updated rate case.
Does the regulation have any forms attached, like a tariff form or anything like that?
No.
No. I mean, back in the day when the commission first exerted jurisdiction over pole attachments, I think it was a 1983 administrative case. It was the subject of litigation in the first place, whether or not the commission could do that. And the Supreme Court upheld the commission's jurisdiction on it. But then there was a series of cases after it, or in the administrative case, instructing the electric utilities to submit their pole attachment tariffs and regs. And the commission in that administrative case would actually review all of the tariffs and the rates and send it back saying, no, you need to change this, 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 and this. I don't know how that would go after that. It would be something to be on an ad hoc basis or an administrative case, but it'd be addressed somehow. And that's something for us to consider as we go down this road of writing regulations.
If there's if somebody files a tariff that you disagree with, is there a case that they file and say, here's what they do a tariff filing?
They do a tariff
And
filing.
then there's a notice that goes out, right? That they
They
file
would
a
have to
tariff.
do, for any change in the tariff, pursuant to the statute, you'd have to give 30 days notice to the commission. And
Okay.
currently, all tariff filings in section, or O11 require you to give notice to customers.
Right.
The notice might be if it's a change in, it depends on the nature of the change, and so obviously it would depend on what the tariff said, but generally, almost every single change would have to be noticed. There might be
They
very.
really only notice to current customers, because you can't give notice to,
Yeah, you would only give notice to.
I gotta guess who my customers are gonna be.
Yeah,
Right.
it would only be, it's only ever noticed to current customers.
Only- yeah.
So, but any tariff that's filed, it wouldn't go into effect for 30 days unless they request expedited, which it could be 20, but I wouldn't really anticipate that in this situation. But and then the commission can suspend it, obviously for a period of time while they review it. Or if it goes into effect and, if you're talking about like an attachment procedure or something that, an attacher finds out about later, thinks is inappropriate, you could, the recourse would be to file a complaint and say, and then the commission could
Okay.
look back at the tariff and determine whether or not it's appropriate or not.
Yeah, figure either the tariff provision's inappropriate or unreasonable, or how it's applied.
Right.
The tariff provision might be fine. So, and, you could, usually a tariff filing comes in, the commission reviews it, they can choose at that point to recommend the commission suspend it or not. But if nobody protests in a lot of tariff provisions, then, the commission might let it go into effect without
suspending it.
Has the Attorney General's office been involved in this process to any extent so far?
They have been put on notice on all these things, but the people who typically have dealt with the Public Service Commission over there are no longer there. One is the Secretary of the Cabinet, and one is the Executive Director here. So there really is only one attorney that has any experience with Public Service Commission over there, and he's up to his eyeballs in alligators. So the Office of Rate of Invention is stocked with people,
Yeah.
good attorneys, but they're all new. They don't know a lot of the applicability of this.
And they are provided, because that's kind of a good point, they are generally provided notice of every tariff filing, so.
Okay.
All right. Do you all have any other questions? Once
None
again,
for me.
April 17th for comments, and we may amend that to allow for, after that, maybe reply comments too, to say, no, they're wrong, we're wrong. Like, a lot of finger pointing, I like that. I will have the website updated with a bridge number for the meetings next week, so people can call in and participate remotely. I don't know if we can get it set up in time for tomorrow or get the notice out for that, but I'll give that to you. And once again, I think the email link for providing comments is on the website and was on the letter that was sent out to the representatives. It is, in fact, I'll give it to you one more time. I haven't given it to you yet, but I will give it to you. It is psc.regulations@ky.gov
And what is that the email for?
for submitting comments, written comments.
Can you repeat it one more time, sir?
No, you get it one time, that's it, I'm
That's it,
sorry. I mean, it's sorry. PSC
Dot regulations?
at ky.gov.
Okay,
Or you can mail them into the commission here.
okay.
But that's in the email that went out to everybody,
Right.
that link is.
So we have a meeting scheduled tomorrow, one for the 11th, and I believe we have, in the letter that went out to the utilities, I think we have some scheduled for after that, or at least have it reserved, depending on how much more interest there is in discussing this batch of regulations. The next ones to go out will be the ones that are electric centric. So you all might be back. We'll try to schedule it around the spring meet at Keeneland.
Be nice.
Get out of here before post time. All right. Thank you all so much. If you have any questions, my contact information's on there, and says email. Do you have any more, or do you have it?
No, no,
Okay,
no.
sorry. All right, that's it. Thank you all.
Thank you.
Appreciate it.